Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to talk about stun batons and stun canes because there's a lot of these on the market and they're being sold as Canada legal. But there's a case out there that just came out fairly recently, as in earlier this year. And if you've got one of these things, you may want to crack a beer for this video. I'm going to because I'm not the biggest fan of some of the reasoning in this one, but let's have a look at it. So this is the case of the Queen and Ensign Dixon. And I'm not going to go through everything in this case because it's a long case, it's 16 pages, and I just want to get to the main issues with respect to this particular item. So let's sort of cut to the bare minimum here, or the main essential bits here in the facts. So Constable Irving gave the opinion that the cattle prod device found in Mr. Ensign Davis's possession met every statutory characteristic of a prohibited conducted energy weapon, save for being 482 millimeters long. The statutory definition of this type of prohibited weapon is a device that is of less than 480 millimeters. I will discuss this description in further detail later in my decision. Constable Irving also testified that the device, which was made of metal, could be used as a baton to hit someone. So we're talking about a stun baton that is more than 480 millimeters. We'll get to the legal description here a little later. So lastly, I turn to the evidence of Quinn Ray Ensign Dixon. Mr. Ensign Dixon purchased the device he refers to as a cattle prod from a gas station in Mission, BC. He did not recall when he purchased it. So he's not buying this from, some sketchy internet site. He's not buying it from some guy who's, holding open his jacket going, hey man, you want to buy a prohibited weapon? He's buying it at a gas station, and presumably the gas station thinks that they're selling a legal item as well. Gas stations are not normally in the business of trafficking in prohibited weapons. That's contrary to the business model. The device came with a cardboard box with a small fold-out manual. The box had a warning label with a caution not to point the device at anyone to avoid accidental injury. Mr. Ensign Dixon said that at the time of purchase, he did an internet search to determine if the device was legal. He said his search results told him that as long as the device was not over 480 millimeters, it was legal. That's actually, he's got that backwards. It would actually be so long as the device is over 480 millimeters. And that would have been what I'd have told anybody else prior to reading this case. So Mr. Ensign Dixon admits, though, that he never measured the device. He first said that the box described the device as being 18 inches in length, but then said he did not actually recall this. Yeah, sometimes people are not necessarily the best witnesses. I don't know that they actually really cared about that so much because they had the device, they could measure it. And it was powered by an internal battery. That's relevant, but we'll get to that as well. He's got a whole bunch of reasons as to why he bought this thing. And just to briefly summarize what happened here, there was a bit of an altercation. And apparently this was used sort of for defensive purposes, although no one was struck with it. It was simply a situation where it was produced and there's dispute as to whether it was turned on. All of this goes to the issues of possession of a weapon for purposes dangerous to the public peace, which I'm not covering here. I just want to look at this issue. Was Mr. Ensign Dixon in possession of a prohibited weapon, a conducted energy weapon, while not being the holder of a license contrary to Section 91 sub 2 of the Criminal Code? So in order for him to be convicted of this, this has to be a prohibited weapon. There's no dispute that Mr. Ensign Dixon did not hold a license for the cattle prod device. The decision, the Queen and Porter, states at paragraph 108 that the onus is on the accused to prove he was the holder of a license that entitled him to possess the device in question. That's also actually what the statute says, so I don't know why they're needing to go to case law here. It's actually written directly into the criminal code. No evidence was called by Mr. Ensign Dixon to show that he held a license, and the evidence of Constable Irving was that a license for such a device was not available. This element of the offense is therefore established. Now, that's not strictly speaking true. There is a firearm business license that could potentially entitle somebody to possess a prohibited weapon, but it's not clear, or it's doubtful that Mr. Ensign Dixon had one. And certainly if he did have one, I expect he would have raised that. So yeah. The applicable description of a prohibited weapon is found at Part 3 of the Schedule to the Regulations prescribing certain firearms and other weapons, components and parts of weapons, accessories, cartridge magazines, ammunition, and projectiles as prohibited or restricted. Why they couldn't have named that, thing a little something less obnoxious, I don't know, but that is just how they named it. This provision describes a prohibited weapon as follows. So this is one entry of something that counts as a prohibited weapon. Former prohibited weapons order number 3. Any device that is designed to be capable of injuring, immobilizing, or incapacitating a person or an animal by discharging an electrical charge produced by means of the amplification or accumulation of the electrical current generated by a battery, where the device is designed or altered so that the electrical charge may be discharged when the device is of a length of less than 480 millimeters, and any similar device. And that last bit is going to be the key bit here. So this basically describes a stun gun, is the sort of common way people phrase this. Now, keep in mind that for something to be a prohibited weapon, aside from certain knives, it has to first be a weapon. And so the reason why that matters is because this also, otherwise we'd have issues with this potentially applying to things like electric fences, although electric fences are usually longer than 480 millimeters. I think you could theoretically make an electric fence that is super tiny. I'm not sure why you'd want to, but theoretically. Or electric mouse traps, the ones that use a current to kill mice. So those things wouldn't normally count because they're not weapons per se, unless you decide to use them as one. So the elements of the prohibited weapon are as follows. And there's actually one missing here, which is the one I just told you about, the fact that it has to first be a weapon. But this breaking it down is sort of a common exercise. This is the essential elements. I've talked about this in other videos, but this is breaking down that definition into the critical bits that the Crown has to prove here. So they're going to go through this in order. So 1, any device that is designed to be capable of injuring, immobilizing, or incapacitating a person or animal. 2, by discharging an electrical charge. 3, produced by means of the amplification or accumulation of the electrical current generated by a battery. 4, where the device is designed or altered so that the electrical charge may be discharged when the device is of a length of less than 480 millimeters. And 5, any similar device. So this is kind of breaking it down into digestible chunks, if that makes sense. With respect to the first element, being a design capable of injuring, immobilizing, or incapacitating a person or animal, Mr. Dixon suggested that the cattle prod would at best only slightly injure a person or animal. Well, the problem with that is that only slightly injuring is injuring. It's like being only slightly pregnant. So that's not the best of factual scenarios here. So Mr. Dixon acknowledged that when he purchased a cattle prod, it came in a box that contained a label warning not to point the device at any person because of the risk of accidental injury. He also acknowledged that he never tested the device. Now, the label itself, there's case law on what these labels mean. I don't know that that label itself can be taken as proof here. That seems to be a hearsay issue. We don't know the accuracy of the label. It might be mere puffery. You're allowed to use puffery in terms of advertising, where you say, oh, this is the best product on the market, knowing that it's not actually the best. It's just, that doesn't actually have any meaning. You're just kind of talking up your item. So Constable Irving did test the device, although not on himself, as he believed it would cause him injury. At a minimum, he felt the device would cause small burns to the body. Constable Irving's evidence was that the cattle prod device was capable of injuring a person or animal. Mr. Dixon conceded this, even though he felt the injury would be small. Thus, the first element of a prohibited weapon is established. Now, on this case here, if we didn't have Mr. Dixon conceding that there would have been an injury, I would have said that this would have represented an error, because here there's no testing. There's Constable Irving's theories as to what this thing would do. But I mean, I can have all sorts of theories, and if you're scared to test the device on yourself, you got to find some other way to test it to determine, is this actually going to cause some injury? Maybe you can go and buy a side of beef and test it on the beef. and say, hey, look, it burned this. That would indicate that it's probably going to burn a person, something. We don't have that here. Even just like, here is the voltage, here is the amperage. Some sort of expert evidence, but we don't seem to have that here. So, but because he says, yeah, it would, he agrees that it would cause injury to an animal, that's enough. Constable Irving demonstrated that the device emits an electrical charge when activated. Mr. Enchin-Dixon also conceded that the cattle prod emitted an electrical charge generated by way of a rechargeable battery. This establishes the second element of a prohibited weapon. So that one's not going to be in a whole lot of dispute here. Constable Irving gave the opinion that the electrical charge was produced by means of either the amplification or accumulation of electrical current. I accept this opinion based on his knowledge of how conducted energy weapons work. This establishes the third element. Now, I don't know what the evidence was here, but fair enough. The judge agrees that this is what, that he has the expertise to determine that. Moving on. I find then that the cattle prod meets the device, or cattle prod device meets the first three elements of the statutory description of a prohibited weapon. The fourth element is that the device must be of a length of less than 480 millimeters. Mr. Enchin-Dixon's cattle prod device measured 482 millimeters in length, which sounds to most people like, okay, we're good to go. Pack up. That's an acquittal. Let's move on. But I got more highlighted text here, so there's more to this one. Constable Irving gave the opinion that, aside from the 3 millimeter difference in length, the cattle prod device met every other characteristic of a prohibited conducted energy weapon. As such, the Crown says that the cattle prod device is a similar device as referred to in the statutory definition. So the similar device is becoming the issue here. Mr. Enchin-Dixon disagrees. He takes the position that the definition set out at Section 6 of the former Prohibited Weapons Order, number 3, is ambiguous and therefore must be resolved in his favor. So there is a principle of statutory interpretation for criminal law that says if you can't really figure out which meaning it might be, you go in favor of the accused. And that basically is because Parliament gets to write the laws and the accused doesn't. And somebody might genuinely read an ambiguous section and think that they're behaving according to the law and then be confused. And we don't really want to punish those people. So those two kind of ideas are what's behind that principle, as well as, general constitutional principles, presumption of innocence, etc. So the law regarding statutory interpretation is set out in the decision Bell Express View Limited Partnership v. Rex, 2002 SEC 42, where the court approved the following statement from Dreger's Construction of Statutes. Today, there is only one principle or approach, namely, the words of an act are to be read in their entire context and in their grammatical and ordinary sense harmoniously with the scheme of the act, the object of the act, and the intention of Parliament. Now, this, is kind of unclear, but it basically says you have to look at the entire thing and try to see sort of what they're trying to do. This is kind of a purposive interpretation approach. So it is only where a real ambiguity is found in the interpretation of a statute that other rules of interpretation come into play. One such rule is that, in the case of penal statutes, the interpretation taken is the one that favors the person whose liberty is at stake. Now, the problem with this, Bell Express View as applied to penal statutes is that it basically has been applied to largely extinguish that interpretation that favors the person whose liberty is at stake, often in order to get convictions. And it seems to me that that interpretation is actually an interpretation that should have a bit more life. Not that a judge kind of after the fact determines, well, it's clear, I have some issues with that. So let's keep on. I turn now to consider the meaning of Section 6 of the former Prohibited Weapons Order number 3. The difference between the cattle prod device and the device described in the statutory definition is a length of 3 millimeters, which isn't much. Mr. Enchin-Dixon argues that the measurement restriction of not less than 480 millimeters is a fixed standard that cannot be departed from. He argues that the law must be certain and that a person should not be left asking, how long is too long? That's a good argument, right? That makes sense. Stated another way, if I'm permitted to depart from the prescribed length of not less than 480 millimeters, then at what length is a device no longer a similar device? Mr. Dixon argues that such uncertainty is not acceptable. And really, when you think that they set a hard cutoff like that, they kind of mean the hard cutoff, right? That sort of says, hey, this is what the limits are. If I go fishing and they say, hey, listen, you can only keep a fish if it's greater than 30 centimeters, and I go, hey, I've got this 32 centimeter fish, I shouldn't be going, well, 32 is kind of like 29, and so therefore I'm going to be, losing my fishing license and eating a whole bunch of fines. When they set up a hard limit like that, it should be kind of a hard limit. And there's an unreported decision of the Queen and Wadden, which is a Vancouver file, and Judge Giardini was asked to decide if a conducted energy device measuring 483 millimeters in length fell within the definition of a prohibited weapon. The defense argued that the prescribed length of 480 millimeters was a cutoff point, and that above that length the device was not a prohibited weapon. The judge decided otherwise, stating at paragraph 64 that the difference of 3 millimeters is not determinative in this case because the regulation goes on to say when the device is of a length less than 480 millimeters and any similar device. In my view, the conducted energy weapon found in Mr. Wadden's possession on November 26 is a similar device to the one described in Regulation 6, Part 3. Mr. Dixon submits that I should not follow the Queen and Wadden because Judge Giardini did not indicate in her reasons for judgment that she considered whether there was any ambiguity in the meaning of the legislation. So basically saying that case is a bad case, don't follow it. And here's why. So Mr. Dixon further submits that the elements of the definition of prohibited weapon are fixed requirements and that the term any similar device does not modify those fixed requirements. With respect, I do not agree. If the reference to any similar device cannot modify the prescribed elements, then that term serves no purpose. Given that the term any similar device is a part of the legislation, it must have meaning. Yeah. All right, let's talk about that, because the flip side of this is that if the 480 millimeters is something that can be overruled by the any similar device, then it doesn't have any meaning. We're in this question of what is legal and what is not. Certainly the law was intending to ban like a pocket stun gun, but what if it's, 500 millimeters? What if it's 500 meters long? Where is the cutoff? Like, what is there any cutoff? Is this just? It seems to me that they've actually taken that 480 millimeters thing and essentially eliminated all meaning from that in order to save the meaning of any similar device. Now, there's places where I can think of that any similar device here might apply here, in the sense of you might say, well, I would say that if we're going to leave any similar, something to be kind of like, what is the meaning of this? The 480 millimeters has a very clear and intended meaning. We might say, listen, I don't know what the meaning of any similar device is. I don't know what that purpose is, why they included that. But I can very easily tell why they included the length of less than 480 millimeters. And just as a bit of background, you might be wondering, why do they leave that in there? Well, because cattle prods exist. Cattle prods are a thing, and cattle prods are used by farmers. They wanted to make sure that a cattle prod would remain legal and something that you could possess. And now any farmer who owns a cattle prod is going to be sitting there going, well, okay, this thing is 515 millimeters. Is that sufficiently different than 480 millimeters? Or what if it's, 485 millimeters? I don't know. So this is a real quandary. And I think that this case creates some serious problems. The reference to any similar device follows a list of qualifications. In drafting the legislation in this manner, I find that the reference to any similar device allows the court to classify a device or weapon as being a prohibited weapon if there are any if there are similarities to any of the listed elements. That gets real broad real fast. I mean, at that point, we're saying, what does this mean exactly? Because it's not any of the listed elements. Really, this was intended to cover all of the things, right? It's a prohibited weapon when all of these things are true, not when simply one of them is true. Uh, if we say any of the listed elements, that gets to be a real problem. Like, is a Jacob's ladder a prohibited weapon? Is, one of the, I forget the name of them, the sort of electrical arcing spheres that you see at science exhibits, is that a prohibited weapon? I don't know. Like, after this decision, it's very difficult to say what this means. It follows then that I do not see any ambiguity in Section 6 of the former Prohibited Weapons Order number 3. Really? Because this seems to be fairly ambiguous now, or at least fairly vague. There's also no need for me to determine the required degree of similarity before a device can be considered a prohibited weapon. I need only determine if a device with a length of 482 millimeters and having all other prescribed elements is a prohibited weapon. I am of such a view. I find that the cattle prod device belonging to Mr. Enchin Dixon is a prohibited weapon within the meaning of the criminal code, given its extremely close similarity to the prescribed description found in the legislation. Now, I'm just going to stop here and take a bit of issue with this approach, and it's an approach that shows up in all sorts of judicial decisions. The thing is judges aren't just, when they're deciding legal issues like this, you have to not just apply, say, okay, well, this one is, good enough. We're talking about setting out legal rules. We're talking about setting out legal rules that the public needs to be able to follow. We're in a situation where we need to be able to understand what the law means. And so there is absolutely a need to determine what the required degree of similarity is. The proper approach, in my view, for something like this would be to say, here is what the legal test is. Here is what the standard is. And then apply that to this particular item so that you have a clear test that then other people can use to actually figure out what to do, how to run their lives. If I see this thing at the gas station, can I buy it or will I go to jail? Or if I am the gas station and I'm selling these things, should I keep selling them or will I go to jail if I do that? This is, I think, a real problem because we end up with, a situation where before this case, I would have felt very confident in saying that a 482 millimeter long cattle prod is not a prohibited weapon. Now we have this case and that's thrown that into some serious doubt. So I don't really know what to make of this case other than to say, I don't like it. And I don't like it not just because I don't like the results. I've never actually felt the need to buy one of these things. But I know lots of people have, and they have done so having read the law, having looked at commentary from people who knew what they're talking about, and said, hey, listen, I think that this is a legal item. And now that's in question. So they say, I conclude that Mr. Enchin Dixon is guilty of the charge that on June 8th, 2019, he was in possession of a prohibited device, specifically a conducted energy weapon, while not being a holder of a license contrary to the Criminal Code, Section 91, Sub 2. Yeah, I'm not a fan of this case. As you can tell, this, I think, is a real problematic approach. The 480 millimeters, I would suggest, was clearly intended to mean something. It was intended to, to have some significance. And, we might say, listen, produced by means of the amplification or accumulation of the electrical current generated by a battery. Well, what happens if you have a sufficiently powerful enough battery and that it doesn't need an amplification or accumulation? It doesn't need capacitors. It's just a real big battery. That might seem to be a similar device, but it's really, now we have this thing where it's any similar device means that we can rule out some of these things. Can we rule out the device designed to be capable of injuring, immobilizing, or incapacitating a person or animal? Can we rule out the electrical charge? Can we rule, like, which parts of this are optional and which parts are required? Rather than getting a clear legal rule out at the end of all of this, what we've ended up with is something where if you ask me what this section means, assuming this case is good law and is going to be upheld by a further court, which if I was facing a charge of this, I'd be certainly arguing that it should not be followed, and for all sorts of reasons. It's just very unclear what this law means. I couldn't tell you what it actually means anymore. So I'm going to try to follow up and see if this case has been appealed. As I've noted in previous videos, there's all sorts of reasons why cases might not be appealed, even if they are appealable. Appeals are expensive. Lots of people don't have money for them. And a lot of people just, at the end of the day, they say, listen, I'm okay with I just want to see this case end. Lots of people end up dealing with cases where they, by the time they're done with it and they've been convicted, they're just tired. It's a lot of stress. It's a lot of work. It's a lot of, and they say, I don't want to go through this again. I can't do it. So that's, it's unfortunate. I don't like this case. I really don't like this case. And a lot of you guys out there watching this are probably also not liking this case for very different reasons, because I know a lot of people out there have bought these things. And I know some people out there are selling these things. And I wouldn't, given this case exists, I would not want to be holding on to an electrical shocking device of any length. And, it's frustrating, I guess is the way I'll put it. So at this point, I'm kind of just expressing my disapproval, which I don't see how we can just say that length requirement is is optional. And apparently from the facts of this, there was a confrontation. There was some stuff about, maybe he was not behaving in a way that he should be behaving. But at the end of the day, I feel like the court should have acquitted him on that one, just on the basis of, sorry, that has to be a hard limit. Otherwise, this doesn't mean anything. So that's about it. Thank you for watching. I know that this video is not going to make a whole lot of you happy, but it is what it is, and I kind of feel the need to share it with you. I'm really hoping this thing is under appeal, but we'll find out. I'll try to leave that in a comment in the video later. So thank you for watching. I also want to thank my Patreon supporters at the $50 level: Jonathan Wheeler, Jason Elliott, Canada's National Farms Association, Mike, Kyle Martin, Jean-Guy Toussaint, the CCFR, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited and Marc-Olivier Demour. And at the $20 level, Raymond L. McKinnon, Matt Ward, Mark Whittington, Jane Babin Luxor, Dale Nesbitt, Cameron Johnson, Bruno R., Andrew Elsich, and Aaron Delsalt. Thank you as well to all of the $10 supporters who will be in the crawl immediately following, as well as all of my supporters and all of my local supporters as well. Thank you once again for watching. I hope this has armed you with knowledge, and I wish I had better news for you, but this is a case I ran into, and I felt it was kind of important to share with you guys, because I don't want to see anybody getting busted for stuff like this just because they thought they were following the law. That is the thing that I find most frustrating about practicing criminal defense, is how often you end up with people who didn't mean to do anything wrong. They didn't mean to harm anyone. They didn't mean to take anything that wasn't theirs. They didn't mean to break any laws. They were trying their best. They were engaging with the law in order to make sure that they understood it. And they still end up facing charges and sometimes getting convicted. And I hate seeing that. I think that is, every time that happens, I feel like that's a failure of our system. So I want to do whatever I can to try to stop that from happening. Anyway, see you next time.